Hi, my name's Emily Kyle. Thank you so much for joining me. So, the question today is, how do I transfer property to somebody else when I pass away and avoid probate? So, it's a really good question, and I'm not a real estate attorney. But remember, when you add somebody on as a joint owner, whether it's a joint owner on real property or on a bank account, you have made them a current owner of that asset. So if you want to take them off later, you need their permission and they're going to have to sign off on it. And if they had some liabilities, that's possible that that asset is now at risk to pay those debts or liabilities because they own some percentage of that asset from a titling perspective. The other thing is there might be some tax consequences. First, whether or not you've made a gift to that person during your lifetime, and also what their tax basis in that asset may be when they've received it as a gift versus when they got it, if it was an inheritance, they got it at death. So for real estate in Arizona, we have something called beneficiary deeds, which is a deed that can be recorded that only goes into effect when you pass away. So it says, I own this property. When I die, it goes to Marissa. Then it becomes Marissa's immediately upon my death. And she'll just file my death certificate and it's her asset then. There's no probate, there's no administration, it's hers. Now you want to be conscientious about that though, right? What if there aren't any other assets you're leaving that person and they can't afford to take care of it? Well, they might have to sell it, which is fine. They have ownership, so they would have the ability to do that. So just think about whether that's what you want to have happen or not. The other thing is if you put more than one person on the beneficiary deed, they all own it equally. So if they don't care for each other and don't like each other, when it comes time to sell or manage that property, they're all going to have to work together because they're all owners of it immediately upon death. But it is a really great way to avoid probate. And if you don't need a trust, then you can skip over that trust process, have a will, and do a beneficiary deed. There are lots of states that have beneficiary deeds, or sometimes they call them transfer on death deeds or pay on death deeds, but not every state has those. So if you have property in a different state, you'd want to make sure that they have some similar process to allow for an easy administration of that property upon your death. I hope that's helpful. And oh, another thing, the beneficiary deed must be recorded while you're alive. If it doesn't get recorded until after you die, it's not a valid beneficiary deed. Unlike pretty much any other deed that can be recorded after death, a beneficiary deed must be recorded during your lifetime. So I hope that's helpful. Again, I'm Emily Kyle. Thank you so much. And if you have any other questions, please reach out and maybe we'll answer your question. Thank you.